All right, we're doing CRW 2603, Learning Unit 7.
2. 64. Learning Unit 7 Crimes Against the Person 16 Learning Outcomes. When you have completed this learning unit, you will be able to demonstrate your understanding of the requirements for abduction by explaining the possible liability of an accused for this crime. Demonstrate your understanding of the requirements for murder by explaining the possible liability of an accused for this crime. Demonstrate your understanding of the requirements for culpable homicide by explaining the possible liability of an accused for this crime. Demonstrate your understanding of the requirements for assault by explaining the possible liability of an accused for this crime. Demonstrate your understanding of the requirements for assault with the intention to do grievous bodily harm by explaining the possible liability of an accused for this crime. Demonstrate your understanding of the requirements for pointing of a firearm by explaining the possible liability of an accused for this crime. Demonstrate your understanding of the requirements for various offenses in terms of the Domestic Violence Act by explaining the possible liability of an accused for this crime. Point 7.1 INTRODUCTION. In this learning unit we discuss VE crimes against the person, namely abduction, murder, culpable homicide, assault, and pointing of a rearm. And then we also consider some offenses in terms of the Domestic Violence Act. Point 7.2 Abduction. Joubert, Chapter 6. In our law, abduction is regulated only by common law. Point 7.2.1 Definition. A person commits abduction if he or she unlawfully and intentionally removes an unmarried minor from the control of his or her parents or guardian, without their consent, intending that he or she, or somebody else, may marry or have sexual intercourse with the minor. 65 CRW 2603/17.2.2 Elements of the crime. The elements of the crime are the following: 1. The removal, 2. Of an unmarried minor, 3. From the control of his or her parents or guardian, 4. With the intention to marry or have sexual intercourse with the minor, 5. Without the consent of the parents or guardian, 6. Unlawfulness, 7. Intention. 7.2.3 Removal. The perpetrator, X, must remove the minor, Y, from one place to another. X may be either a male or a female. In the vast majority of reported cases, however, X is a male and Y, the minor, a female. This is the reason why, in the discussion which follows, the masculine form will be used to refer to the wrongdoer, X, and the feminine form to refer to Y. The removal need not be forcible. In fact, in almost all cases of abduction, Y consents to the removal. It is not required that X should himself EECT the removal or be present at the time of removal. It is sufficient if X and Y arrange to meet at a place away from the house of the parents. Nell 1923 EDL 82, Jorgensen 1935 EDL 219. Point 7.2.4 Unmarried minor. 7.2.4.1 Roman Dutch law. The person who is removed, Y, must be unmarried and a minor, and may be either male or female. In practice, Y is usually a female. Under Roman Dutch law, the age of majority was 21, but this was recently changed by Section 17 of the Children's Act 38 of 2005. It stipulates that a child, whether male or female, becomes a major upon reaching the age of 18 years. Point 7.2.4.2 Customary law. Customary law does not lay down a specific age of majority. Den notes that a person is regarded as an adult when he or she is able to procreate. Only then will both male and female have the capacity to marry, and may they be given in marriage. An arrangement for marriage may be made by the two families, but this is only a promise, and does not constitute a marriage when the arrangement is made. Even though customary law is a source of law in South Africa, the statutory age of majority of 18 years has not yet been tested by a court. Point 7.2.5 From control of parents or guardian. Y must be removed from the control of his or her parents or guardian. The legal interest protected by this crime is the authority of the parents or guardian over the minor. 66 Abduction is committed against them, and not against the minor, because, as will be pointed out later, Y's Y's consent to the removal does not afford X a defense. It is possible that the parents no longer exercise any authority or control over Y, for example where Y has left the parental home to go and live and work elsewhere, and the parents no longer even know where Y is herself and no longer even care what she does. If this is the case, X does not commit abduction if he takes Y from where she happens to be staying to another place. Beswidenhout 1971. 4. SA 32. T. In such a case, the parents still legally have the right to refuse consent to Y's marriage, although in actual fact they no longer exercise any authority over Y.7.2.6 intention to marry or have sexual intercourse with minor. The crime is only committed if X removes Y with a certain aim in mind. This aim must be that somebody, usually X himself, either marries Y or has sexual intercourse with her. For the crime to be complete, it is not required that the marriage or sexual intercourse should actually have taken place. All that is required is an intention on the part of X to achieve one of these aims. The mere temporary removal of a girl from her home in order to have sexual intercourse with her is not yet abduction. X must intend to remove Y from her home either permanently or for a substantial period. If a man wishes to have sexual intercourse with a girl, but it is impractical for him to do so at her parents' home where she lives, and the couple then drive to another place for the purpose of sexual intercourse, whereafter he immediately brings her back to her home, he does not commit abduction. Such conduct may amount to mere seduction, which does not constitute a crime. In order to distinguish between seduction and abduction, the removal must last at least a substantial period. L 1981, 1, SA 499, B. In Ismail 1943 CPD 418 it was held that a period of 24 hours was sufficient, and in Killian 1977, 2, SA 31, C, a period of only 8 hours was regarded as sufficient. The intention to marry Y or have sexual intercourse with her must exist at the time of the removal. If the removal is for an innocent purpose, and X only decides thereafter to have sexual intercourse with Y, the crime is not committed. Sashi 1976, 2, SA 446, and it is important to note that the crime is also committed if it is X's intention that someone other than himself should marry Y or have sexual intercourse with her. Adams 1911 CPD 863. This draws attention to an important and sinister aspect of the crime, namely the situation where unscrupulous persons entice minors to leave their homes in order to engage in indiscriminate sex with strangers, often for remuneration payable to the minor. 7.2.7 Without the consent of parents or guardian, the removal must take place without the consent of the parents or guardian. Whether or not Y has consented to the removal is immaterial. In practice, Y most often consents to her removal, yet the crime is committed even if she does not consent. If Y does not consent, then, apart from abduction, X can also be guilty of the more serious crime of kidnapping, a crime which, in cases in which the victim is no longer a child, is committed only if the victim does not consent to his or her removal. 67 CRW 2603/1. What must be lacking is the consent of the parents or guardian to both the removal and the purpose of the removal. 7.2.8 Unlawfulness. There must be no ground of justification for X's conduct. The removal may conceivably be justified by necessity, for example where X acts under compulsion. 7.2.9 Intention. The form of culpability in this crime is intention. In terms of the general principles relating to intention, X's intention must relate to all the elements of the crime. X must therefore know that Y is an unmarried minor, Churchill 1959, 2, SA 575, and that Y's parents have not consented to the removal, Sitten 1954, 4, SA 20, C, 23. Activity X, a 40-year-old female, entices one 12-year-old girl to leave her home and work as a prostitute for X and her husband. Y leaves her home voluntarily, but without her parents' consent. What crime does X commit? 17 Feedback. X commits either statutory or common law abduction. 7.3 Murder. Joubert, Chapter 6.7.3.1 Definition. Murder is the unlawful and intentional causing of the death of another human being. 7.3.2 Elements of the crime. The elements of this crime are 1. 68. Please note that the concepts causation, unlawfulness, and intention were dealt with in detail in the CRW 1501 module in the discussion of the general principles of criminal law. The only new element which has not yet been discussed, and to which you should pay particular attention, is the requirement that another person must be killed, and, more particularly, that the object of this crime must be a living human being. 7.3.3 Another person. It is a requirement of the crime of murder that another person must be killed. Consequently, if someone tries to commit suicide, they cannot be charged with attempted murder. Where X assists or incites another person to commit suicide, it could, depending on the circumstances of each case, amount to murder, attempted murder or culpable homicide. Ex parte Minister Van Justitie, in Re S.V. Grotjahn 1970, 2, SA 355, a. Also CRV Pavirat 1940 AD 213, which dealt with a suicide pact. 7.3.4 A living human being. The person who was killed must have been a living human being. In terms of the Criminal Procedure Act 51 of 1977, a child is considered to have been born alive if it is proved that the child had breathed. Prior to 1996, if an unborn fetus was separated from its mother's body and killed, the crime committed was abortion. However, since 1996, the position in our law has changed with the passing of the Choice of Termination of Pregnancy Act 9 of 1996, which legalized abortion in South Africa. 7.4 Culpable homicide. Joubert, Chapter 6.7.4.1 Definition. Culpable homicide is the unlawful negligent causing of death of another human being. 7.4.2 Elements of the crime. The elements of this crime are 1. The causing of the death, 2. Of another person, 3. Unlawfully, and 4. Negligently. You will notice that the only difference between murder and culpable homicide lies in the form of culpability required for each. In the case of murder, intention is required, while in the case of culpable homicide, X must have acted negligently in causing the death of the deceased. 69 CRW 2603/1 Since the elements of causation and unlawfulness were studied in detail in the introductory CRW 1501 module, they will not be repeated here. The only two elements that will be discussed are the elements of causing of death and negligence, culpability. 7.4.3 Causing of death. This requirement of the crime of culpable homicide is very similar to the corresponding element in respect of the crime of murder, and most of the same principles apply. However, with the crime of culpable homicide, the conduct element may also be satisfied by X's failure to act in certain situations. In some cases, a person's death may be the result of X's negligent failure to act where he, X, had a duty to act positively to prevent the death of the deceased. In other words, the conduct element in the crime of culpable homicide may also be satisfied by an omission on the part of X. See the following cases which illustrate how culpable homicide may be committed where X had a duty to act but failed to do so. S. V. Russell 1967, 3, SA 739, and S. V. Chipinge Rural Council 1989, 2, SA 342, ZS, and S. V. Van as 1967, 4, SA 594, A. 7.4.4 Negligence as the form of culpability. Both culpable homicide and murder involve the unlawful causing of death of another human being. However, murder requires the intentional causing of death, whereas culpable homicide does not require intention but negligence. It should be noted that culpable homicide is the only common law offense which does not require intention as an element. The killing of another person is negligent if X should have foreseen that he might cause the death of the other person but did not refrain from his act, even though a reasonable person in X's position would have foreseen this. An example of culpable homicide is a negligent killing during the course of an assault. If X assaults Y and unintentionally kills him, Y, it is usually not difficult to prove that X should have foreseen Y's death. However, negligence must be proven. See S.V. Van as 1976, 2, SA 921, A. 7.4.5 Homicide in African culture. The crimes of murder and culpable homicide, as discussed above, are unknown in African culture. In its place, a form of homicide is found where vengeance and restitution are the main issues to be resolved. When a person is killed, a blood feud between the deceased and perpetrator's families is created. According to Den, the younger male members of the deceased's family would traditionally reciprocate to mete out vengeance against the perpetrator's family. This is, however, not done in practice anymore, as national courts now deal with the criminal liability of perpetrators of homicide. Restitution remains an important aspect of homicide, and blood wealth is still paid in some African customary systems. Family members related to the father of the perpetrator are required to pay compensation to the family of the deceased. Den mentions that, in Dinka culture, the standard payment is 40 cows, although this might vary from region to region. 707.5 Assault Joubert, Chapter 6.7.5.1 Definition. A person commits assault if she unlawfully and intentionally 171 applies force, directly or indirectly, to the person of another, or 182 inspires a belief in another person that force is immediately to be applied to her. 7.5.2 Elements of the crime. The elements of this crime are the following: 1. The application of force, or the inspiring of a belief that force is to be applied. 2. Unlawfulness. 3. Intention. 7.5.3 Ways in which the crime can be committed. The act of assault may take different forms. First, it may consist in the application of force to the person, body, of another. Secondly, it may consist in inspiring fear in Y, and, more particularly, a belief in Y that force is immediately to be applied to her. The RST possibility may, in turn, be subdivided into direct and indirect application of force. The different ways in which the crime can be committed may thus be illustrated as follows in a diagram. We shall now discuss each way of committing the crime separately. 71 CRW 2603/17.5.4 Application of force. Direct. The RST way in which the crime can be committed is through the application of force. Here, one must distinguish between direct and indirect application of force. We RST consider the direct application of force. The direct application of force is the most common way in which the crime can be committed. This is the form of the crime which corresponds most closely to the ordinary layperson's idea of assault. For example, X punches Y with her ST, or kicks her, or slaps her in the face. The fact that Y does not feel much or any physical pain is irrelevant. Thus, X may commit the crime even if she only spits in Y's face or trips her so that she stumbles. 7.5.5 Application of force. Indirect. The application of force may also be indirect. In this form of the crime, X commits some act which results in Y's physical integrity being infringed, as in the following examples: X sets a vicious dog on Y, or X snatches away a chair from under Y just as she is about to sit on it, resulting in Y's falling to the ground, or X derails a train on which Y is traveling, or X frightens a horse on which Y is riding so that Y falls from the horse. Note the following two examples from our case law for convictions of assault where the application of force was indirect. 1. In Marks 1962, 1. SA 848, N. X gave 3 glasses of wine to drink to each of 2 children, aged B and 7 years. The children drank the wine and became sick as a result. The younger child could not walk at all and was in a semi-conscious condition. X was convicted of assault. The fact that the harm or discomfort was internal rather than external was held to be irrelevant. 2. In a 1993, 1. SA 600, A. X, a policeman, forced Y, whom he had just arrested and taken to the police station, to drink his own urine. X was convicted of assault. The court rejected the proposition that since urine was not poisonous or dangerous, the forced drinking of it could not constitute assault, holding that the forced drinking of any substance constitutes assault. 7.5.6 Inspiring fear of immediate force. Inspiring fear or a belief in why that force is immediately to be applied to her also constitutes an act of assault. Here there is no physical contact with, or impact on, Y's body. This is a rather unusual way of committing the crime, one which, in certain ways, departs from the layperson's conception of what constitutes assault. You should, therefore, tick. 72. Good note of the rules below setting out the preconditions for holding someone liable for assault in this form. For a person to be convicted of assault in this form, the following rules apply. 1. The threat must be one of violence to the person of Y. Thus a threat by X to damage Y's property is not sufficient. 2. The threat must be one of immediate violence. Thus a threat by X to cause Y some physical harm in the future, e.g. the next day, would not qualify as assault in this form. 3. The threat must be one of unlawful violence. If X is entitled by law to threaten Y with violence should Y not behave in a certain manner, such as to leave X's house or premises, she does not commit assault if she threatens Y. Thus X may always threaten Y to use force to defend herself or her property. 4. Y, the complainant, must subjectively believe that X intends to carry out her threat, and that she is able to do so. The essence of this type of assault is the intentional inculcation of fear in Y. If Y does not, in fact, fear the threat, no assault is committed. 7.5.7 Bodily harm in customary law. Personal injuries not resulting in death are of less concern in African customary law. This does not mean that it is of no consequence. If a person is harmed in such a way that he cannot perform his duties in the larger family, punitive and/or restitutive measures may be taken. The general rule is that restitution should be made so that the family does not sue as a consequence. If it is a minor in the family that was harmed, then the restitution will go to the family head, while the entire family will be the owners of the restitutive payment if the head of the family is harmed. Activity X threatens to shoot Y, but the object X is holding in her hand is not a real pistol, but only a toy pistol. Y knows that the object X is brandishing is only a toy pistol. Consequently, Y does not experience any fear. Does X commit assault on Y? 18 feet back. X does not commit assault because Y did not fear any immediate bodily harm. Even if X happens to believe that the object she is holding in her, whereas it is in fact only a toy pistol, but Y knows that the object is only a toy pistol, X does not commit assault, because Y does not fear any immediate bodily harm. 1. In previous descriptions of this type of assault, it was required that X's conduct should contain some act or a gesture, and that the crime could accordingly not be committed by words alone. However, the general consensus among modern writers is that X commits this form of assault even though she does not perform any act or gesture but merely threatens Y verbally. Thus, if Y turns a corner to be confronted by emotionless X who, with a gun in her hand commands, "Hands up," X commits assault. 73 CRW 2603/17.5.8 Unlawfulness. The use of force or the inspiring of fear must be unlawful. This means that there must be no ground of justi cation for X's act. The following are examples of instances in which X's act would be justi and, i.e., not unlawful. 1. Private defense. Y threatens to kill or assault X. In order to defend herself, X uses force against Y. 2. Ochale capacity. X is a police ochale who uses force to arrest Y, who has committed a crime in her presence. 3. Parental authority. X gives her naughty 7-year-old daughter a moderate hiding in order to discipline her. 4. Consent. A. X is a surgeon who cuts open Y's body in the course of the performance of an operation on Y to which Y has consented. B. Y is a sportswoman, netball or hockey player, who who is injured by X in the course of a sporting contest in respect of which Y has voluntarily consented to take part. 7.5.9 Intention. X must have the intention to apply force to the body of another or to inspire in her fear of the application of force. This implies the following. 1. The intention may take the form of direct intention, indirect intention, or dolus eventualis. An example of an assault in which X has intention in the form of dolus eventualis is the following. X throws stones at birds. There are children around playing. She foresees the possibility that, if she throws a stone at a bird, the stone may miss the bird and strike one of the children. Although she hopes this will not happen, she nevertheless decides to go ahead, unperturbed by the possibility of her injuring a child. She throws a stone, which misses the bird she aimed at and strikes a child. 2. In cases of assault which take place by means of the inspiring of fear, as opposed to the application of force, X must know that her conduct will inspire fear in Y. This means that X must believe that her threats will inspire fear in Y. 3. According to the ordinary principles relating to intention, X's intention must incorporate knowledge of unlawfulness. This means that X must know that her conduct is not covered by a ground of justification. Thus, if X believes that she is entitled to act in private defense because she fears an imminent unlawful attack by Y on herself, whereas she is in fact not entitled to private defense because Y does not intend to attack her, she lacks the necessary intention to assault. 4. According to Creighton 1981, 1. Essay 1097, a. Intoxication may lead to X lacking the intention to assault, in which case X must be found not guilty. 5. It seems doubtful whether our courts would be prepared to recognize provocation as a ground for excluding the intention required for ordinary assault. They do recognize that provocation may exclude the special intention required for the qualified assaults, such as assault with intent to do grievous bodily harm. 74. 7.6 Assault with the intent to do grievous bodily harm. You must study the discussion of this crime in Joubert, Chapter 6 on your own. Activity. X and Y are arguing over a girl. X becomes angry and draws a knife from his pocket. X tells Y to forget the girl and to go home. Y refuses. X tries to stab Y with the knife. Y manages to avert the attack and, even though X tries to stab Y more than 10 times, he always misses. Y EES and runs to the police station to lay a charge of assault with the intent to cause grievous bodily harm. X is charged with this offense. X's defense is that, although he had tried to stab Y, Y had not been injured at all. Therefore he could not be found guilty of the crime. Can X succeed with this defense? 19 Feedback. X's defense will not succeed. For a conviction of assault with the intent to cause grievous bodily harm, it is not required that Y had, in actual fact, suffered serious bodily harm. It is required only that X had the intention to impose serious bodily harm. Thus assault with intent to do grievous bodily can be committed even though no grievous bodily harm is in fact enized upon Y, and even though no actual physical injuries are enized upon him. In Joseph 1964, 4, Essay 54, RA, for example, X drove a truck and deliberately swerved towards Y, intending to hit him, but just failed to hit him. He was nevertheless convicted of assault with intent to do grievous bodily harm. 7.7 Pointing of a firearm. Joubert, Chapter 9.7.7.1 Definition. Section 120, 6. Of the Firearms Control Act 60 of 2000 provides that it is an offense to point any rearm, an antique rearm or an air gun, whether or not it is loaded or capable of being discharged, at any other person, without good reason to do so, or, b. anything which is likely to lead a person to believe that it is a rearm, an antique rearm or an air gun at any other person, without good reason to do so. Although the subsection creates two different offenses, these offenses are so closely related that it is convenient to discuss them as a single offense. 7.7.2 Elements of the offense. The elements of the offense are the following. 75 CRW 2603/1. 1. The pointing of. 2. A rearm or other article. 3. At any person. 4. Unlawfully and. 5. Intentional like offense created in this subsection may overlap with the crime of assault in the form of inspiring fear of immediate personal violence. 7.7.3 Conduct. To point at the proscribed conduct consists simply in pointing the rearm at somebody else. In order to secure a conviction, the state need not prove any of the following: 1. That X read a shot. 2. That the rearm or article was loaded. 3. That the rearm or article was of such a nature that it could be discharged. In other words, that it was capable of ring a shot. The expression point at can be interpreted in more than one way. First, it can be interpreted narrowly as meaning the pointing of the rearm at Y in such a way that, if discharged, the bullet would hit Y. This interpretation was adopted in Van Zyl 1993, 1. SACR 338, c. 340G. Secondly, it can be interpreted broadly as meaning the directing of the rearm towards Y in such a way that, if it were discharged, the bullet would either strike Y or pass in her immediate vicinity. This wider interpretation was adopted in Hans 1998, 2. SACR 406, e. 411, 412. Although support for both interpretations can be found in the case law, it is submitted that the latter broader interpretation is the correct one. The reasons for following the broader interpretation are the following: 1. One can assume that the intention of the legislature was to combat the evil surrounding the handling of rearms on as broad a front as possible. 2. The narrow construction of the expression would make it unduly difficult for the state to prove the commission of the offense, since it would be extraordinarily difficult to prove beyond reasonable doubt that, if the bullet had been read, it would actually have hit Y, and not merely have missed her by millimeters. 3. The harm sought to be combated by the legislature, namely the arousal of fear in the mind of Y of being struck by the bullet, would exist irrespective of proof that the bullet would have actually struck her or just missed her. 7.7.4 A rearm. What must be pointed is a rearm, an antique rearm or an airgun or anything which is likely to lead a person to believe that it is a rearm, an antique rearm or an airgun. 76. The Act gives long technical definitions of the words rearm, antique rearm and airgun. For present purposes it is sufficient to know the gist of the definition of a rearm, namely any device manufactured or designed to propel a bullet or projectile through a barrel or cylinder by means of burning propellant, and also to bear in mind that, according to the definition of the word in section 1, a rearm includes the barrel or frame of the device. The EECT of the words or anything which is likely to lead a person to believe that it is a rearm, etc. in the definition of this offense is that X may commit the offense even if she points a toy pistol at Y, provided that the toy pistol is such that it is likely to lead a person to believe that it is a real pistol. 7.7.5 Any other person. The rearm or article as described in the Act must be pointed at a person. Thus, to point it at, for example, an animal, cannot lead to a conviction. 7.7.6 Unlawfulness. The requirement of unlawfulness is not specifically mentioned in the definition of the offense, but the words without good reason to do so in the definition are wide enough to incorporate grounds of justification. It is clear that X will not be guilty of the crime if, for example, she points a rearm at another while acting in private defense, or if X is a police officer lawfully effecting an arrest. 7.7.7 Intention is not expressly required in the definition of the offense in subsection 6. It is, however, highly unlikely that the legislature intended to create a strict liability offense. It is also unlikely that it could have intended mere negligence to be a sufficient form of culpability, since the words point at prima facie denote intentional behavior. The corresponding offense in the previous legislation, which was replaced by the present Act, required that the rearm be willfully pointed. It is therefore submitted that the form of culpability required for a conviction under the subsection is intention. This means that X must know that, 1. What she is handling is an object described in the Act, namely a rearm, antique rearm, airgun or anything which is likely to lead a person to believe that it is such an article. 2. She is pointing the weapon at another person. Thus, if she thinks that she is pointing it at an animal or an inanimate object, she lacks intention. 3. There is no good reason for her conduct and that it is unlawful, that is, not covered by a ground of justicatiae. Mere negligence is not sufficient. It is submitted that, according to general principles, intention in the form of dolus eventualis is sufficient. 77 CRW 2603/1. Activity 1. X takes a toy gun which resembles a 9mm parabellum gun and points it at Y. Whilst X is pointing the gun at Y, the police arrive at the scene. X is charged with pointing of a rearm. Can X be convicted of this offense? 2. How do our courts interpret the term pointing of a rearm? 20 Feedback 1. X can be convicted of the offense of pointing of a rearm. Firstly, X pointed the gun at another person, Y. Moreover, the EECT of the words or anything which is likely to lead a person to believe that it is a rearm, etc. in the definition of this offense is that X may commit the offense even if she points a toy pistol at Y, provided that the toy pistol is such that it is likely to lead a person to believe that it is a real pistol. Since the toy gun that X pointed at Y resembled a 9mm parabellum gun, Y believed that it was a rearm. 2. There is case law to support a narrow and wide interpretation of the term pointing of a rearm. In Van Zyl 1993, 1. SACR 338, c. 340G, the court said that pointing means that the bullet will hit the person if it is discharged. This is the narrow interpretation. In Hans 1998, 2. SACR 406, e. 411 to 412. The court held a wider view that pointing refers to either striking the person, or narrowly missing her. It is submitted that the wider interpretation is correct, as the legislature did not specifically mention that hitting the person is a requirement. Even if the bullet narrowly misses the victim, then pointing would have taken place. 7.8 Offenses in terms of the Domestic Violence Act 116 of 1998. You must study the discussion of this section in Joubert, Chapter 6 on your own. Activity X and Y, both adult males, have been out on several dates and share an intimate sexual relationship. They do not live together, but X often stays over at Y's home. Recently, X has become verbally abusive to Y and has even punched Y on one occasion. What protection would Y be entitled to? 21 Feedback. X and Y's relationship qualifies as a domestic relationship in terms of the Act, which also covers homosexual relationships. The Act covers verbal abuse as a type of abuse. Once it is established that there is a recognized relationship and type of abuse, Y would be entitled to apply for a protection order in terms of the Domestic Violence Act. 78 Summary Abduction 1. 7 different elements can be identified in the crime of abduction. They have all been explained above. Murder 2. The crime of murder consists of 4 elements. The elements of causation, unlawfulness, and intention were discussed in your introductory course. The only new elements are another person and a living human being. Culpable homicide 3. Murder is the unlawful and intentional causing of the death of another person, while culpable homicide is the unlawful and negligent causing of the death of another person. 4. For murder and culpable homicide, it is required that another person be killed. Assault 5. See definition of assault above. 6. The act of assault may consist in either the application of force to the body of another person or in the inspiring of fear or a belief in why that force is immediately to be applied to her. The application of force may be direct or indirect. 7. Grounds of justicatiae which may possibly be raised on a charge of assault are private defense, ochale capacity, parental authority, and consent. 8. Intention is the required form of culpability for the crime of assault. Negligence is not a sufficient form of culpability for this crime. 9. It is possible to commit attempted assault. Assault with the intention to do grievous bodily harm. 10. All the requirements for an ordinary assault apply to this crime, but in addition there must be intent to do grievous bodily harm. 11. Whether grievous bodily harm is in fact incised on the victim is immaterial in determining liability. It is only the intention to do such harm that is in question. 12. Important factors which may indicate that a person had such an intention are, for example, the nature of the weapon or instrument, the way in which it was used, the degree of violence used, and the part of the body aimed at. Pointing of a rearm. 13. See definitions of the OINS above. 14. The expression point at should be interpreted as directing the rearm towards Y in such a way that, if it were discharged, the bullet would either strike Y or pass in her immediate vicinity. 79 CRW 2603/1. 15. The gist of the definition of a rearm is any device manufactured or designed to propel a bullet or projectile through a barrel or cylinder by means of a burning propellant. OINS in terms of the Domestic Violence Act. 16. Note the obligations that the Domestic Violence Act places on police or jails. 17. The Domestic Violence Act does not create an OINS of domestic violence, but certain types of abuse within a domestic relationship may amount to domestic violence. 18. Domestic violence consists of two elements, a domestic relationship, and certain types of conduct that constitute domestic violence. 19. A domestic relationship is a relationship between the complainant and respondent that could take a number of different forms. 20. The conduct or act in domestic violence comprises conduct by one of the parties to the domestic relationship in a manner towards the other party that amounts to domestic violence. 21. If the abusive conduct within a domestic relationship constitutes a crime, charges may be laid against the respondent, e.g., physical abuse may constitute the crime of assault. Contravening a protection order also amounts to a crime. 22. Note the powers granted to the police in terms of the act regarding seizure of arms and dangerous weapons, accompanying the complainant to collect property, and arrest. 6. Test yourself. 1. Any abduction. 4. 2. Write short notes on the following requirements for a conviction of abduction. A. Removal of the minor from the control of the parents or guardian. 5. B. The intention with which the removal must take place. 7. 3. Any murder and culpable homicide, and distinguish between the two crimes. 5. 4. Explain why it is irrelevant which method was used to cause the death of another in the crime of murder. 2. 5. Write short notes on the requirement that the death of another person must be caused in order to constitute murder. 5. 6. Which form of culpability is required in the crime of murder? Explain. 5. 7. Explain whether consent is a valid ground of justification on a charge of murder. Refer to decided cases. 5. 8. X's girlfriend Y falls pregnant. When Y is 8 months pregnant, she tells X that he is the father. She also demands that X marries her and says that if he refuses, she will claim alimony from him once the baby is born. X does not want to get married and also does not want to pay alimony for the child. He decides to shoot Y in the stomach in order to kill the baby. One evening, X goes to Y's house, sees Y standing in the kitchen and rests a shot through the window which hits Y in the stomach. The baby is killed but Y survives. Discuss whether X may be convicted of murder in respect of the killing of the unborn child. 5. 9. Name the requirements, or elements, for a conviction of culpable homicide. 4. 80. 10. Y explain the requirement of culpability, negligence, in the crime of culpable homicide. 5. 11. Any assault. 2. 12. Y set out the different ways in which assault can be committed. 2. 13. Give 2 illustrations from our case law of assault committed by the indirect application of force. 2. 14. Discuss the principles relating to assault in the form of inspiring fear in another that force is immediately to be applied to her. 5. 15. List the grounds of justification for excluding unlawfulness as requirement for the crime of assault, and provide an example of each. 8. 16. Discuss the requirement of intention in assault. 5. 17. Give an example of assault in which X has intention in the form of dolus eventualis. 3. 18. Y explain the meaning of grievous bodily harm. 3. 19. Discuss the meaning of grievous bodily harm in the crime of assault with intent to do grievous bodily harm. Refer to case law in your answer. 10. 20. Do any the offense of pointing a rearm. 3. 21. In order to prove the requirement of an act, i.e. to point at, in the offense of pointing a rearm, the state need not prove certain circumstances. Name these circumstances. 3. 22. The requirement of an act in the offense of pointing a rearm consists simply in pointing the rearm at somebody else. However, the expression pointing at can be interpreted in more than one way. Describe the different interpretations of this expression, indicate which interpretation should be followed, and give reasons why such an interpretation should be followed. 5. 23. Give 2 examples of instances where the pointing of a rearm is not unlawful. 2. 24. Explain what it is that the accused, X, must know in order to have the intention required for the offense of pointing a rearm. 3. 25. While there is no such offense as domestic violence, certain forms of abusive conduct within a domestic environment may amount to domestic violence. What are the 2 elements of domestic violence? 2. 26. According to Section 1 of the Domestic Violence Act, a domestic relationship is defined in a number of different ways. List the different relationships recognized by the Act. 6. 27. In Section 1 of the Domestic Violence Act, one party in a domestic relationship must act in a manner towards another party that amounts to domestic violence. List the forms of conduct, including crimes, which are considered as domestic violence in the Act. 8. 28. What are the purposes of a protection order in terms of the Domestic Violence Act? 2. 29. What powers do the police have in terms of the Domestic Violence Act? 4. 81 CRW 2603/1. Learning